Good morning, everyone. I'm Matt Ewald, Senior Director of Events and Live Journalism for the Texas Tribune. Welcome to those joining us in person here in Austin and those joining us online for our conversations with Representatives Jeff Leach and Joe Moody titled, "Is Justice Served? Legislative Intervention and the Death Penalty." I'd ask our panelists to come on up and join us on stage as we get started. This fall, Moody and Leach orchestrated an unprecedented legislative maneuver that temporarily spared the life of death row inmate Robert Roberson just before he was scheduled to be executed. Today, in conversation with the Tribune reporter Kayla Guo, we'll hear more about their efforts to permanently avoid Roberson's execution and their concerns about the science behind the shaken baby syndrome diagnosis that prompted a jury to sentence him to death. Our program will run an hour, with 45 minutes of moderated conversation and 15 minutes of Q&A. Here in Austin, we have a mic for our in-person audience. Our virtual audience, joining us from around the state, can also submit questions online at our Q&A portal. That's at texastribune.org/ask, texastribune.org/ask. Thank you to all those around the state who make the journalism of the Tribune, including events like this, possible by becoming a Texas Tribune member. To learn more and become a member, visit texastribune.org/support. Let's briefly meet our panelists today and then get started. Representative Jeff Leach, Republican of Plano, is in his 6th term representing House District 67 in Collin County. During the 2023 legislative session, he was appointed to serve a 3rd term as chair of the Committee on Judiciary and Civil Jurisprudence. Additionally, he served on the Committee on Criminal Jurisprudence. Representative Joe Moody, Democrat of El Paso, who represents Texas House District 78, chairs the Criminal Jurisprudence Committee and is founder and co-chair of the Criminal Justice Reform Caucus and serves on the committees on Judiciary and Civil Jurisprudence, House Administration, and Redistricting. Our moderator and Texas Tribune reporter Kayla Guo has extensively covered the legislative and legal battles stemming from Roberson's scheduled execution. While she's formally moving into a new role covering climate and energy for the Tribune, she'll continue to cover the Roberson case for the Tribune. We thank all for joining us today, and with that, I turn the program over to Kayla.
Thanks so much, Matt. Hello to you both. Good morning, and thank you for being here. I know it's a busy week, but I appreciate you both being here. I think I want to just jump right into it. The first thing I would love to cover or get into is the subpoena, which is what, for people who might not remember, led the Texas Supreme Court to stay Robert Roberson's execution in October. Could you tell us the story of how the subpoena came about? When did you decide to do it? It came at the end of a very long hearing, the day before Robert's execution was scheduled. What did you think would happen at the time in issuing the subpoena, and what made you decide ultimately to go through with it? I guess either of you.
There is no short answer to that question. I'm trying to figure out where I could start in explaining how we got there. But we get involved in cases from time to time. Jeff and I and many others in the House. Robert's case was one of those that we got engaged with and got interested in, talked with, organized a letter to the Board of Pardons and Paroles, did the advocacy work that we've done before in cases like Melissa Lucio and others. This was another example of us getting involved and engaged. It became clear that all of the red flags that were popping up in Robert's case did not seem to be stopping the process. It seemed like no one was hitting, Jeff has used the phrase hitting pause, like, hey, there's a lot of problems here. And I think for both of us, it was a little unexpected, a little disconcerting. When you shine a light on something like this, like we've done in the past, you expect like, okay, the wheels will stop moving. Let's make sure we're doing all the right things. We've checked all of these question marks that are out there. And I think we fully anticipated that was what was going to happen. It became abundantly clear in the beginning of October that maybe that wasn't going to happen. And so what is our job as legislators? What do we have to do? And Jeff, on a call, gosh, I don't remember when exactly, said, well, we need to have a hearing. like we did with Melissa's case. Let's have a hearing. Let's talk about this. Let's bring it to light. We have a statute here that's not being enforced. It's not being utilized. Let's talk about it. Well, that's our job as legislators. And he said, shoot, just issue a subpoena for Robert himself. Come testify. And that was when the idea was conceived of. But I will tell you that I did not anticipate that we would issue it at the beginning of that hearing. I think what happened as that hearing progressed made it abundantly clear that we had to take the unprecedented step to issue that subpoena. And that was a unanimous vote on that committee to do that.
Yeah. He answered the question.
Okay. Well, the subpoena delayed Robert's execution, and it has yet to be rescheduled. But it also set off a fierce political battle in addition to the legal battle in the Texas Supreme Court that has since been resolved. The Attorney General called on you, Rep. Leach, to resign at one point related to your efforts to this. What has that been like? Has that sort of political aspect of it been surprising to you? Was that surprising to you when it started, and was it frustrating? And sort of relatedly, I wonder what you think is driving this push to move forward with Robert's execution.
So, by the way, thank you for hosting this conversation and for your extensive coverage of this case. And it's always great to share the stage with my friend Chairman Moody. This this case and what we've been through over the past several weeks in the course of the last few months, as we've diligently pursued justice, has truly been unprecedented. You know, normally as committee chairmen and as legislators, as lawyers, when you're dealing with complicated legal issues like this, whether it's in the criminal or civil context, there is precedent that you follow, that you try your best to follow, so you can see what's happened in similar cases in the past and similar fact patterns, and you try to apply the law, and you know, we're trained to do that. That's what we do. But in a case like this, which just at every step of the way was so unprecedented, we really were in a position where there was no instruction manual, there was no rule book for this, and our pursuit all along has been for justice to be served, for the truth to be arrived at, and for justice to be served. And when we're talking about the, no pun intended, the execution of the death penalty for someone whom several months ago I believed could potentially be innocent, now I fully believe is innocent, it's a worthy pursuit. And so we have attempted at every step of the way to work aggressively, but to work collaboratively and amicably with all of the branches of government and everyone involved to try to see that justice is served. Unfortunately and unpredictably, and in many cases shockingly, there have been forces that have worked against us in that effort, and which has not slowed us down or stalled us at all. It has actually propelled us more. So when the system fails somebody, as it has failed Mr. Roberson, it is our job, as unprecedented as what we've done may have been, it is our job and our duty to fulfill our oaths of office and to fight for justice, and that's what we've done.
What sorts of precedents do you think your work on Robert's case itself has set, if any?
Well, I mean, I think in a very limited way, if there are cases in the future where we want to hear from someone, even people on death row, the Texas Supreme Court says, absolutely. Our power to do that is inherent in our power in the legislature. It cannot, in one very limited sense, it cannot interrupt a scheduled execution. That we know now. We did not know that before. We know that now. But we now have a very clear path. This is not the last case that Jeff and I are going to work on. If I can be so bold as to predict that, there will be another one that comes forward that will have significant problems. It's just the nature of the way we've always worked through this. So, like, Jeff talked about it. It is working earnestly, working diligently, being creative, because the goal is for justice to prevail. And sometimes you got to get creative to raise awareness about an issue like this. Our job as legislators, comes and goes with the legislative session. But we do have the ability to shine a light and raise awareness about cases that we feel are problematic. We are talking about the largest power, the most intrusive power that the government has at its disposal to take someone's life. We should not treat that lightly. And so, we will continue to, essentially use these tools. We now understand where we can use certain ones of them, certain of them. But our pursuit to get to the justice in these situations is going to continue. And this is the latest iteration of understanding what we can do, the power of shining a light on the problems of these cases and waking people up. I think there's people in the legislature that probably had never thought through some of these issues before, and that's great that they're engaged now. There's nothing better than more people understanding what these systems are, because then we get a better outcome.
And the group of lawmakers who are behind you both on this and advocating for Robert, and beyond lawmakers, but his public advocates, has been bipartisan, it's been wide-ranging, politically, ideologically. I wonder what that makeup of that group and the two of you, what that has said to you about both his case and the potential to work on these sorts of issues together, and what you make of that, the nature of this group behind your efforts.
I'm glad you asked that question, because Joe and I are here on this stage, and gladly and proudly so. But the reality is, as we've seen, there are so many wonderful people in this Army that should be up here and could be up here talking about their experiences and their perspectives and the work that they've done. Our legislative colleagues, I think I saw Representative Busey walk in. Representative Harrison has just been remarkable on this. Representative Hull, you've got so many others, our committee members, and then just dozens and dozens and dozens of other legislators who were not forced to. We're not in legislative session. They literally have looked into this case and are so troubled by it, like we are, that they've been compelled to speak out and to roll up their sleeves and to work. See Mr. Roberson's attorneys who are here. Gretchen has just been remarkable is the only word I can think of. Dr. Phil, John Grisham. If I could have scripted this, there's no way we could have scripted this or predicted this over the past several weeks, but I think it speaks to how compelling this cause is. And when you look at this army of, there's probably other words I can use to describe it, but army of happy warriors in the pursuit of justice who have come together from different political backgrounds, different parts of the state, different parts of the country, coming out of the woodwork to say, hold on, you death penalty opponents like Joe and death penalty supporters like me, saying, hold on, that we cannot do this. This can't be something that the state of Texas can go forward with, and but for the actions of the two of us, but so many other people, Robert Roberson would not be alive today. He was within 20 feet and 20 minutes of being killed by the state of Texas. And so I'm grateful to have played a small role in that. I won't apologize for anything we've done, and hope that more and more people with more power than we even have will wake up to what we've woken up to and seen what we've seen, and will ultimately do the right thing.
Speaking of that legislative intervention related to the death penalty, you've both worked on death penalty cases before. It doesn't seem like, at least you, Chair Moody, think this will be the last one. What sorts of changes do you want to see, or do you hope to enact this session? What legislative actions are you considering related to the junk science law, or just stemming out of Robert's case?
Sure, and I've already filed a bill that addresses a number of the concerns we took out of the hearing. Let's make sure that the junk science law applies to the punishment phase of trial. as well as it already does to guilt, not guilt. And then there's a number of other changes that we can have that we took on. We had a former judge from the Court of Criminal Appeals testify at our hearing, Judge Elsa Alcala. She gave us a number of suggestions about tweaks we could work on with the Article 11073 writs. And those are all great ideas. But on top of that, Jeff Leach has sent to the other side of the Capitol multiple times banning the death penalty in law of parties cases. Senfronia Thompson has carried for years a bill that would create a front-end mechanism to take individuals with intellectual and developmental disabilities out of the death penalty. Because the U.S. Constitution, as has been interpreted by the United States Supreme Court, says you can't execute them. And Texas has failed over and over and over and has been told multiple times, you need to put a system in place that makes sure these people don't track into the death penalty. We need to pass that. It is 20 years past due. So those are the types of things that we need to do. We need to make sure that when we give jury instructions on the death penalty, they're not confusing, that they know what they're doing, that they hold life and death in their hand. Let's be clear about what we're doing. And Jeff said it, whether you're a supporter or an opponent of the death penalty, doesn't matter. It should be a fair system. Everyone can agree on that. Everyone can agree on that. And so let's have honesty in our jury instructions. There's all these things we've passed 1,000,000 times over in that house. We need people to start paying attention to the fact that when these don't change, lives are literally on the line. And they may not be lives that some people care about. Because when someone's in a cell out in the middle of nowhere, you may not care about them. But the important part of our work is to see the humanity in every single person that goes through the criminal justice system. It is incumbent upon us to do that. No matter what they're being accused of, no matter what they've been convicted of, there is still humanity and dignity, and our rules have to make sure that justice and fairness meets those people in every single corner of our state.
Yeah. Do you think Robert's case and the legal battles around that will help you maybe finally codify some of those things you mentioned this session? How does it change your efforts from past years and give it better chances or worse chances, or what's your read on that?
Our hope is certainly that shining a light on this case and other cases that we've worked on, like the Melissa Lucio case. Our hope is that that in the halls of government and every branch, in courthouses, in state houses, in our state house, in the executive branch, that people will wake up to the reality that that the system can be, and in many ways is, broken. As a conservative Republican who talks a lot about, and proudly so, campaigns on the many ways in which government fails fails the citizens. We talk a lot about the protection of fundamental liberties and rights, the chief of which is the right to life. And we conservative Republicans, we campaign on these issues. Well, this is right. This is in that. We talk about the rule of law. We talk about justice. I've heard many of folks, rightfully so, from my side of the aisle, who have talked about lawfare and courts that are out of control and the injustice. And they're right to speak out on that. Well, this case is a perfect example of injustice. And so as a conservative, we ought to be speaking out more than anyone on these issues. And not only speaking out, but figuring out ways in the building across the street in the Capitol to improve our laws, to strengthen our laws, to make sure that these fixes are, or that these problems are fixed and these holes are filled. So yes, I do believe that this case will lead to legislative statutory changes, and it should. It's woken people up. It's helped us greatly, and our goal is to continue in full pursuit of legislative changes in any ways possible.
Yeah, a group of us went to go meet with Robert. Had about 90 minutes to sit down with him, talked about a whole host of things. But a number of the things he said really stick in my mind. But one of them was, he certainly didn't know what was. It was about a week out from his, a couple weeks out from his execution. He did not know what was going to happen. All of us have to grapple with our mortality at some point. but very few people are told the day and the hour. So I don't know how he processed that. I don't know how he was processing it, but in the conversation we had, what was conveyed to me was he didn't know why he was here. He didn't know why he was in this position. But what he said was, the only thing I can think is, God's using me for something bigger. So when I think about making the changes to our laws to make this more fair, even Robert, in that moment of very difficult, trying to comprehend what's coming for him, he said, maybe this is so that other people don't have to go through what I went through.
And I guess if you do codify any new legislation that might come too late for Robert, maybe it could help him directly. But I wonder what remains for him. What sort of recourse does he still have at this point? I know, Chair Moody, you alerted a hearing for December 20th. Is the plan to have him testify there, and how does that benefit him?
Yes, I mean, it's clear. The Texas Supreme Court was very clear and said that if we want his testimony, we can have it, except in a very limited circumstance. And so we have wanted to hear him. Detective Wharton, when he testified in front of us, said the reason he failed in the pursuit of justice in that case is because he did not see Robert. He did not hear him. We as legislators need to see and hear him, and the Texans that care about these issues need to see and hear him. It informs our decision making. And yes, I have asked the Texas Department of Criminal Justice to comply with the statute that is non-discretionary. Please bring this person before the committee to testify. I've given them until 5 o'clock today to say whether they're going to do that or not. If they don't, then we'll issue a subpoena and we'll go down that route. The court has 3 times said, please work together. And over and over and over again, the legislative branch has tried to make accommodations to simply take someone's testimony. And we have not had the other branch of government engage meaningfully in figuring this out. I don't think it's that complicated.
Yeah, I'll pull back the curtain even more. I mean, the Supreme Court made very clear in its holding from a couple weeks ago that what we did was valid, that our subpoena was valid, that we can. I mean, it's unequivocal in their holding that the Supreme Court said, executive branch, you have to honor a legislative subpoena and work with them to achieve the objective of that subpoena. Now, they went into detail on whether we can actually stop an execution, and I think the Supreme Court got it right. Our intent was never to impede upon the governor's constitutional and statutory authority to be the ultimate and final say on whether a death penalty sentence should be reprieved or commuted or stayed or whatnot. But we're not going to relent. I can speak for myself and Joe, and I know our members of our committee. We will not relent in the pursuit of justice for Mr. Roberson. Not going to happen. What the Attorney General's office, I feel like, is doing right now is trying to delay as much as possible and not work with us on. They're basically ignoring the Supreme Court's order, knowing that in a month or so, when the new legislative session convenes, our committee goes away because it does every session. When the new legislature convenes, the existing committee and its jurisdiction and its power and anything it's done in the past is gone. And my belief is that the Attorney General's office knows that and is trying to delay until the start of the next session, which is just horrifying and maddening to me. But they should be very clear that even if that is the case, next session, a new committee, if they want to thumb their nose in the face of the legislature that egregiously and blatantly, then they can be and should be assured that a new committee next session, whether it's my committee or Joe's committee or someone else's committee, will issue a new subpoena if we have to. And I'm hopeful that that's not the case.
Has that been happening in the past? I think it's been 2 weeks since the Supreme Court order came out. Can you give us a sense of what those interactions have looked like, what that delay tactic has looked like in those?
Sure. I mean, I asked immediately, through the channels they asked me to communicate through, because the same agency say we're not allowed to talk to the Texas Department of Criminal Justice anymore, which is ridiculous. But so I communicated through the channels they asked me to communicate through, and I said, all right, in light of the court's order, I intend to have another hearing. Can you just simply answer me this question? Do you want me to issue another subpoena, or can we just agree? The court has now 3 times said, please work together. And I asked this in no uncertain terms. Can we agree? Because I've been a lawyer for a long time. Jeff's been a lawyer for a long time. There's lawyers here. We agree on lots of stuff. Hey, we know that, all right, let's make sure this witness has to produce. Okay, we'll agree to a time and a place. Let's just get this done. And I asked, I said, can we just do the same thing that lawyers do across the state every day, which is come to an agreement about what, my subpoena's good. The court said it is. We don't have to go through the mechanics of that if we don't want to. You and I can just agree. Produce Robert on this date, and we're good to go. There was a plan already on paper to produce him at the Capitol. I have it because they agreed to it until they put the brakes on it. And so the question I get back was, just completely off base, didn't have anything to do with what I asked. They couldn't answer the simple question of, can we agree, or do you want me to issue a subpoena?
Is this
And
the
they've
Attorney
refused-
General's office?
Yes,
or?
they've refused to answer that very simple question. And so if they're going to do, I've been in this business long enough. That's just a foot drag. I get it. So I set the hearing and I gave them a deadline. I don't know how to come to a reasonable conclusion when the other side will not even answer a simple question. And all of that to say, and the mechanics of this and pulling back the curtain is fine. And ultimately, what I want people to take away from that is, why? Why? Why don't they want to hear from Robert? Why do they not want the legislature to do this? Why? For what reason? And there is no legitimate answer to that question.
There is none. And what's happening right now is, well, I'll just say this. Look, the Attorney General's office can disagree with the legislature and can debate the legislature. We welcome that. But they cannot disregard the legislature. They can't. And that's what's happening right now. And we are not going to allow that to stand without a fight. And so you're going to see it from us too. You're going to see it from a lot of other legislators who I've talked to them, who are on actually both sides of this case, who say, man, if the Attorney General's office continues to just ignore the legislature and disregard your legislative, statutory, constitutional, now upheld by the Supreme Court authority, then there's going to be hell to pay. Sorry.
In your brief to the Supreme Court, the first one, I think Chair Moody, you had described, or the brief described, that you had received an offer to sign a joint letter, both of you, admitting that Robert is a murderer and you should never have intervened in this way. Have you received other sorts of asks like that, or pressure to drop your advocacy? Anything else like that nature?
No. I've got to censor myself when talking about that letter, because I thought someone was joking with me when I sent it to me. That was a letter that was sent to us knowing that we would never sign it. It is written in a way that says, make sure that they never sign this, because it was saying, we're idiots. We made a mistake. We're so sorry. Robert's a murderer. All this. I was like, okay, so why am I putting my name on this? And so, I mean, there was maybe another version of that letter. Like, I don't want to go too far into the nuts and bolts of it, but no, there became a conversation about the litigation we were in versus the subpoena versus his testimony. Is there a way we can kind of rectify all this? That the legislature just wants to take his testimony. Can we go there? We can go take his testimony there as a traveling committee. So there was a lot of conversations about how to kind of get this to conclusion. And ultimately, none of that came to fruition. So we went forward with litigation at the Texas Supreme Court and, let the cards fall where they may.
What do you hope to gain from Robert's testimony, and how do you see it helping him?
Well, we don't know what we hope to gain. We certainly want the ability to talk to him and to ask him questions. We believe that it's necessary for our legislative purpose of, at the end of the day, this is about Texas law not being followed, a law that the legislature has passed, that Governor Perry initially signed, that Governor Abbott came back in 2015 and strengthened. We have this law for a very important reason, the junk science law, 11073, and we believe strongly that it is being ignored, misinterpreted, and that the will of the legislature, as I said, is being disregarded. And so our testimony from Robert, we believe, getting testimony from Robert is necessary to figure out how we can fix it, to make sure that it's followed going forward. At the end of the day, that's what this is about. Who can argue with that? Well, a lot of people have tried to. Our goal at the end of the day is not, I don't want Mr. Roberson walking the streets of Austin today or tomorrow. We've been pushing for answers to questions, for ultimately a new trial. We believe that he's owed that's the right and just thing to do. And so us hearing from him is really to get legitimate questions answered. Yeah. Go ahead.
No, he is a man uniquely situated to talk about this. Also, as someone with autism, I want to know what that experience was like. What is it like to have a lawyer that at his trial level that is essentially not reflecting Robert's wishes in the trial? What does that look like for him? What is it? What is the process from there look like from his perspective to try and get his truth told? As someone who's met with him for 90 minutes, I do believe he'll have some ability to discuss some of those things. I think, some of that may be, is he going to be able to talk about the intricacies of Article 11073 of the Texas Code of Criminal Procedure? No, but he can tell you what it did to him. And that's what I think people need to hear. Because at the end of the day, these laws meet real people where they are. And I want to hear his experience because it's very unique. And I think that can help reflect into why we need changes. We do this all the time, right? When we have a bill come up and we bring a witness to come and talk about it, if you do it in that order, they come and talk about it, and they tell you what happened in their life. And this is why we need a change in the law. And this is the law that's going to do it. Jeff has worked on issues related to sexual assault and things of that nature. And victims who had gone through those experiences came to those committee hearings and told of their personal story. It helps inform the legislature why we need it. Put the personal behind the policy, right? And so that's what Robert can give to this conversation.
There are 3 new judges on the Court of Criminal Appeals. They have succeeded 3 judges who all, in at least I believe the last 2 of Robert's appeals, voted to allow his execution to move forward. Do you have any insights into these 3 new judges, if they might think differently about his case? I know this got you in a bit of trouble.
We're not allowed to talk to him anymore.
I haven't texted any of them about this. No, I don't have any insight into how they will rule. But my hope all along has been, whether it's the current judges or new judges, that the right thing would be done and that justice would be served.
Look, opportunity and time is all that we can ask for Robert. And that's an opportunity to have a conversation in front of 3 judges that have not engaged in this conversation. Don't know what their philosophy on this would be. Obviously, I assume that's something that'll be looked at. But no, we don't have any insight into it. But all of these things are on the table, and I hope that, like what Jeff said, is can we get to a place where we can meaningfully address the number of very serious problems in this case. And let's take an honest look at it, because That's not what's happened so far. There's been a process where people have checked boxes, and they can say that it was followed, but the spirit of the law has been violated in this process, and that's what we need to rectify.
Have you been in touch with the prosecuting district attorney? She testified at a hearing that the committee held earlier on before Robert's execution was scheduled. She hasn't requested a new execution date yet. Do you know why? Have you been in touch with her at all?
I haven't since we met. I know that we had had some, we had had conversation in committee that we possibly wanted to bring her back to discuss a number of other matters. I haven't circled back with her to that end, but I'm not opposed to talking to anybody. I was very appreciative of the fact that she spent a long time with us waiting to testify on a very long day. And so, her office was always very open to the opportunity to come back, but no, I haven't had more conversations with her yet.
Okay, I think we will open it up to audience questions.
Let me add on to that answer on that question. In 2000, and my years are kind of running together now, I think it was 2022 with the Melissa Lucio case, when Joe and I held our first hearing on this issue on her case. We invited then District Attorney Louis Sines from, I believe it's Cameron County, to testify in front of the committee. And I when he was in front of our committee virtually, Joe and I and the committee got, at the hearing, initially pretty frustrated at what seemed to be a lack of knowledge and really a lack of care from him for Melissa's case. But during the course of that hearing, and certainly subsequently, and this is really important, to his great credit, Louis Sines said, you know what, I hear the legislature, I understand the questions they're asking, and he, for lack of a better, it's the only word I can think of, humbled himself in his position of power and said, okay, maybe we did get this wrong. And he and his staff went and did what we asked them to do and asked tough questions and looked at the case, took time, and stopped this, what seemed to be at the time, bloodlust for executing her, and on their own, did the right thing. And because of that, there's now a high likelihood that within the next, I hope to be, within the next few months, Melissa Lucio is going to be back home with her family. And so great credit to Louis Sines and his office for doing what we're asking the Anderson County District Attorney to do now, is just hear us and ask these questions and look at this. And if you're not absolutely convinced, if there's any question, any shred of doubt that he's potentially innocent, or whether a crime even occurred, then just stop and let's ask those questions and find the right answers. That's what I'm still hoping is done.
Was your sense coming away from her testimony before your committee that could happen, that she might do that consideration?
No, I mean, I don't know, but the example of Louis Sines is a perfect one. I don't know that I walked away from that hearing thinking that he was going to do a deep dive on that case. That meeting was extremely confrontational, and I think respectful but confrontational. And to his credit, did a deep dive. I'd invite her to do the same thing, and our doors are open. We're willing to work with anybody. If that's the way we want to, happy to go down those trails with everybody, because I think the questions have been laid out very clearly. And so let's go do that work. I'd invite her to have that same, same process to think through that. She wasn't the prosecutor back in the day when this went through, and neither was Luis in Melissa's case. And so it's okay. It's okay. Sometimes I think you get in these lockdown. I've been a prosecutor before. I've been a criminal defense lawyer. Like, sometimes people kind of get locked in, and they just want to defend their conviction, and they get this almost like this pride of authorship to it. Except for there's a person's life that is in the balance. You've got to be able to let that stuff go. It's bigger than any of us, and so I think she should pray on that. And she should think about that. And my hope is her heart can be moved, much like Luis's was, and we can get to a just place.
I have one last question before I want to open it up to audience questions. I know we have people, there's a mic here, and there's a way to submit questions online. My last question is, you've talked about Melissa Lucio at this point. You've both advocated on behalf of other death row inmates. Rep. Leach, you support the death penalty. Has Robert's case changed how you think about the death penalty, how either of you think about the death penalty in Texas and our state's criminal legal system? If you could reflect on how his case has impacted your thinking at all, if at all.
Yeah, it has. And I think all of us legislators, including death penalty supporters like myself, have to be thoughtful about these issues. And so short answer to your question is yes. I continue to maintain support for the death penalty in the most egregious cases where there are not questions like there are in Robert's case. But I do think we need to take a very serious hard look. I think there are others on death row right now, Melissa Lucio, Jeff Wood, others who we need to also ask questions about. And in doing so, we're not weakening the system. We're strengthening the system. Asking questions and doing what we've done, I believe, has strengthened, not weakened the criminal justice system. So yes, it's changed my view, and I would hope that would be the case for other legislators just like me.
Yeah, I think that what this has done more than anything else is that it has brought a number of people who maybe hadn't worked in this space into the very real and heavy issue of the death penalty. It has taken people to death row that probably never imagined that they would be there. And I think in my conversations with people, and like I said, I in 2017, I very publicly changed my stance on the death penalty. I've always told people, I'm not here to tell you what to think about it or what not to think about it. That's the journey you're going to go on. I've been on that journey. But I want to invite you to the conversation. Let's talk about it. Because I guarantee you, as you dig further and further into this, you are going to see the problems and the cracks and the issues because they've manifested themselves in a number of cases and will continue to. And so I just want people to come into the conversation to really dive into it. Because if they do, I do think ultimately they will agree with me. But that's, again, I just want to invite them to start to understand it. It's not easy. And that's why I always tell people, and I see Representative Busey here, and he's been awesome, an advocate for Robert and a very good friend of ours through this process. But, digging into these issues, and I don't, John probably doesn't mind me sharing this, but before the Robert's execution date, he said, I think I might want to go to be there. And he said, what do you think about that? And I said, just be ready, because 9 times out of 10 we don't win these, and so just know that you're going to be in the room with someone that you care about and you've learned about and you've sat with, and you may have to watch them die. And he made that difficult decision to be there. And I'm grateful he was there because we needed him there. While we were furiously filing things at the court, we needed him in that room. But the more people engage in this very difficult process, and it's emotionally draining, I think the more opportunity we have to change our laws. But you do have to get into these things. And I think Robert gives us that ability. His story gives us the ability to get into a very difficult case. This is a child that has died. This is a difficult case. Melissa's case, a child that has died. Difficult facts. But let's explore that together and figure out where we can get to. And if you do that, I think you're going to get to a place where you know that we have to change the way we're doing things.
Thank you both so much. All right.
So as we enter our Q&A period, just a reminder for those viewing online that you can submit a question at texastribune.org/ask. Also, just out of respect for what I imagine to be a number of questions coming in and acknowledging that there are many passionate advocates on the issue and those who bring personal experience, just out of respect for one another, to be as brief as possible in answering your question. Again, just out of respect for our audience. I have one question that was submitted online that I'll read right now for Representative Leach. Darren from Allen asks, when you say legislators have said that if the AG's office continues to disregard the legislative branch, there will, quote, be hell to pay, could you be more specific about the options the legislature may utilize?
Well, my point there is that this is supposed to be a partnership. The branches of government are supposed to work together, and when we've got a branch of government that literally is, like I said, disregarding the co-equal branch of government in the legislature, and yet comes to the legislature every single session, wanting us, needing our help, needing funding, needing us to continue to invest in the important work of the AG's office, and our AG is doing a lot of really good work. But look, if you're going to ignore the legislature and say we don't care about you and we're not going to do what the Supreme Court told us to do, then if we have to, we'll be back in front of the Supreme Court, and I don't think that's going to be. I don't think that should be necessary. And so my hope would be that they will, like us, abide by the Supreme Court's well-written order and help us secure Mr. Roberson's testimony.
Yeah, good morning. Chairman Leach, Chairman Moody, I congratulate you and I commend you for taking this case, because normally people with autism, they ignore. I'm talking about reality of life at this moment. My grandson is 20 years old. He broke a window. He's at a group home because he's a little bit in the aggressive side. And he's autistic, intellectually disabled. He's a man of a 3-year-old, and he's psychotic. So he broke a little window. And the son-in-law, the woman that broke the window, is an attorney. His name is Bobby Barrera, so he decided that my grandson was going to be punished for the crime that he committed. So he contacted the police, and they put my grandson in jail for 21 days. They didn't let me get out. The DA Sally, and another DA, Bianca, they said they have to wait to get him out till Bobby Roberta finished a civil lawsuit against the group home, because he was under the group home care. So he was in jail, he was raped, and I've been advocating for this for so many years. But kids with disabilities, kids with autism have no rights, they have no voice. I don't know if you know that. You know me forever, but they have no voice. So the child was incarcerated for 21 days. He said they just threw him in the bathroom and raped him. And then I got him out of jail, and I hired an attorney. And she told me, and I recorded the conversation. She said, we're not going to get him out. We're not going to dismiss the criminal charge till Bobby Roberta finished his civil lawsuit. The woman charged me $3,000. And nothing happened. And then we already have him ready for him to go to the assisted living center. I would like for you to go and visit that place. That place is ugly, disgusted. I won't put my dog in there, and I don't even like dogs. And this is something that you need to address, because like the Arc of Texas did an interview with me and my grandson, and we have so many people incarcerated as we speak. Kids that they have a man of a 3-year-old, and they've been in jail sometimes for 1 to 3 years. 1 to 3 years. Yes, because, and they don't have, like if you talk to my grandson, what kind of ice cream do you want? You have to say black or white, vanilla or chocolate. And then we have a lot of abuse in the churches too, because they don't accept kids with disabilities. Thank you so much.
Thank you.
Yeah, and I appreciate you sharing your story. I think Robert's case is one that has elevated the conversation around autism and how someone can navigate the criminal justice system when they have, are living with autism. So I think it's woken up a lot of people to the point where some of our testimony that we took was about, if we were going to hear from Robert, like, talk to us about, what that would look like. Because there was some offer to do virtual testimony at some point, which his attorney vehemently opposed, and I agree with her. And so we talked about it in the committee. So why do you think that would be a bad idea? So we got to educate ourselves, and that's important, because the more educated we get on how people intersect with the system and what barriers there are for them, depending on who they are, we can create a fairer system, right? That was something we talked about when they said, TDC, or the OAG's office said, this is the accommodation we're making. And I said, well, the accommodation, you're looking at it through your lens. I'm looking at it through Robert's lens. The accommodation needs to be made for the person who's sitting in the chair, not the people that are driving him to the Capitol. And so, very good points to raise, and I think Robert's case has also been a very important part of the conversation when it comes to either IDD or other issues that present themselves in the criminal justice system.
To go back to something Mr. Moody said, it's human nature to dig in your heels when someone tells you you're wrong. And you may also see a political cost in admitting that a mistake was made. And my question is, how much do you see that in action here? And is there a face-saving way out or a legislative fix for that? That applies to prosecutors, defense attorneys, judges, and legislators. That's human nature for all of us. Thank you.
I'm trying to kind of crystallize where you wanted me to go with that. So I might want to visit with you more, but you can do independent reviews of things. I mean, there's some good conversations that we've had around kind of getting that pride of authorship out of the way. Having some independence. Some offices have instituted conviction integrity units. I think some of our bigger offices should actually do front-end prosecution integrity, right? It's great to look at it in reverse. Perfect, I'm glad they're doing it. Why are they not looking at it going forward? You got to take care of both. So I've always encouraged, and here's the thing, DAs can do that today if they want to within their own policy. I would encourage prosecutors and we should encourage them through our budgets. If we want them to do better and think through these things, let's help them. Let's help them. And if they're going to put people on that are going to review these cases, or they're going to track, if there's a really big case, this is what I would do, is if there's a really big case coming through the system, I'd want someone bird dogging that and thinking about it through a defense attorney's lens. You should be doing that, because you're going to have to take it to trial, and there's going to be a defense attorney there. So your job is to do justice as a prosecutor, not just to seek convictions. So what can we do to encourage a better process in some of these cases? And so, in a case like Robert's, it's at the time, it was science that people relied on, and it just became open and shut. So, don't know that I could blame them for going down that trail, because that's kind of what was going on at the time in science. But certainly now, we should have the opportunity to unpack all that, because the science has changed. And so I think there's a number of ways we can do that, get creative. Some of them could be legislative, some could be budget, some could just us be working with our local prosecutors to encourage them to have some policies in place.
Hi, I'm Nina Satija. I'm a reporter at the Houston Chronicle. It's interesting to hear you both talk about the death penalty and all of the other problems in the criminal justice system. I think Chairman Leach, you've been, or many people on the committee have talked about, we support the death penalty. This isn't about the death penalty. And it was really interesting to hear committee members talk about issues like indigent defense and other things that came up in this case and come up in a lot of other cases. So how do you see that tension? If you go too far, Chairman Moody, if you go too far on the death penalty, do you think that makes it harder to get legislation passed on other issues that affect the broader system? How do you deal with that balance? I think there's always been kind of a tension on, are we talking about the death penalty, or are we talking about the system as a whole and the problems that led to this outside of the death penalty?
So it's important. It's a great question. It's important for me, from my perspective, for us to remain focused, laser focused on this specific case. And I've heard the attacks levied against me specifically. One of which has been that I'm anti-death penalty, and that this is just an end-round way to do away with the death penalty. That is not the case at all. I am in favor of the death penalty. I'm just not in favor of executing potentially innocent people. Okay, and so this has nothing to do with the at no time at any point in the near future is the death penalty going to be abolished in Texas. I'm not pushing for it. I don't know of anyone that is. Secondly, that somehow that I and the committee are trying to impede on or intrude on the governor's constitutional authority when it comes to his powers to grant clemency or reprieves or stays in execution. That is actually not, that we're not staying in our lane. That's what we've been accused of. That's not the case either. I fully recognize and support and respect greatly the governor's role in this. I just simply believe strongly that in all of these cases, when a law is being ignored so egregiously by the courts and by the other branches of government, that the legislature has not an opportunity but a role but a duty to step up and to speak up. And so in this case, that's what we've done, and that's what I remain laser focused on.
Hello, I'm Ed Heimlich. Both of you know me. Representative Leach, I think this should be a headline. The law is being blatantly ignored. That's what you said. They're ignoring the law. Now, correct me if I'm wrong, but our Constitution gives the power to make law exclusively to our Texas legislators, not to our courts, not to the executive division, to you, our legislators. So how can the courts ignore the law? And if they are ignoring the law, it would seem to me that you, as the lawmakers, can overrule their ruling and say, no, this is the law.
Yeah.
The law is that he cannot be held guilty for under junk science.
So here's how I think it's being ignored, and we kind of fleshed this out in committee, and it's going to be a little bit wonky, and I apologize for that. But this is the details matter. We have actual innocence writs, right? We have in our laws, and to be able to avail yourself of that relief, there is DNA evidence required. I think that is part of the process that you have to go through, and that's for actual innocence. This relief is not actual innocence relief. This relief is based on science that has changed. There's a couple other factors, and that it would have changed a defense or could have changed the outcome, or right. This is not an actual innocence claim. This is saying that something was flawed in the evidentiary process. The court has essentially morphed that into requiring that same level of evidence that you would have in an actual innocence claim. These are different claims for relief. So the fact that they are treating it like the higher bar of actual innocence tells me that they are not. They're essentially. They are not applying a different standard in these cases, which they should. The black letter law says they should, but the evidence tells you, and there's a fantastic report from the Texas Defender Service that talks about the 10 years of this law being on the books, and they go into great detail about this. And I would encourage anyone who wants to work on this to understand it, to look at that, because that's how it's being ignored. They've changed the standard, and so they've essentially neutered the relief that was written by the legislature. So how do we fix that, Mr. Heimlich? We go back and make it very clear that this is not the same path for relief, and there's a number of ways we can do that.
This will be our last question of the morning.
Hi, I'm Lawrence Wright with The New Yorker. As you know, I've been interviewing the women on Texas Row for the last couple of years, and I want to commend you for saving the life of Melissa Lucio, who's clearly innocent. There's another woman I'd like to call to your attention. Her name is Kimberly Cargill, and She's gone through all of her appeals. She expects to be executed next year. In her case, the jury found her guilty of a homicide, but there was no cause of death. The coroner could not establish a cause of death. And it's pretty clear that she died in an epileptic seizure. The victim died of an epileptic seizure. She bit her tongue, she bit her cheek. You know, there's no other indication of any other means of death. And this woman has lost all of her chances through the appeals process. This is one of those cases where I think it should be examined. You seem to be the last court of resort in a real sense. And I hope you get reconstituted when the legislature reconvenes. But if you have the opportunity, I wish you would look into the case of Kimberly Cargill. Thank you.
No, I appreciate it. Remember when I said it won't be the last case we work on?
All right. Thank you both so much for coming and speaking to us. Thank you all for participating.
Thank you. Thanks again. Thank you.